Yes, sir. Now you can start it also.
Okay. Now you can see the screen, full
Yes,
screen
sir.
now.
Yes, sir. No, sir, not a
Yeah,
full screen. Now I'm able to see the full screen,
yeah,
sir.
yeah. Okay.
Thanks.
So I'm going to talk to you today mainly about the uh, subject of compulsory licensing, which is in India. And we will start, the my talk will be approximately in this kind of four basic blocks. I'll try to give you a background to this, why it is there and all that. For that, I will ask you a series of questions of which you can think about. And if one or two want to answer on live, you could also answer. And then in India, there's even though the law exists, only one case of compulsory license grant has occurred. We will take a look at that, and then we go to the principles behind it and the law behind it and all that. I will not start with the law because it would not really convey much to you. So it is better to start this way. So let's look at the background. Let me ask a few questions. Now, assume that somebody has taken a patent regarding a toy. Okay, nothing very special about it. It's a toy, and then it has got something special, and then there is a patent on that. And it has never been brought into the market. That means it has not been put into a product. It has not been sold. Now, is there an ethical problem in this? One way of looking at it, I will try to answer this question myself so that you know what I'm talking about it, is that even though there is a patent, nobody really misses this. This is not something that is going to change anybody's life. It is not going to save anybody's life, or it will not improve somebody's life enormously, or anything like that. So this is a patent which has been obtained because an technical innovation has been done, and the Indian Patent Office, which is an arm of the government of India, has granted a patent. Right? So there is no problem even if you have a patent, and if you don't use it and put the product into the market. In this case, we can assume that there is no serious problem. Right? In the patent language, we say that a patent has been put into practice. That is, when you put it into a product and then sell it in the market, the terminology used is that the patent is practiced in India. Right? So that is the first question. Now we will look at another question. The question number has suddenly jumped, but it really doesn't matter. It's question number 2 now. A process patent has been obtained. That means you can have either a product patent or a process patent. Assume that in this case, a process patent has been obtained. It delivers some advantage compared to the existing process for doing the same thing, but it doesn't deliver a great advantage. That means assume that if the energy consumption was 100 units to manufacture something, with this new process, it will take away 2 units of power. Instead of 100 units, you're going to use only 98. It's an advantage, but it's not a very great advantage. And even this is not practiced by the patentee, right? But because there is a patent, nobody else can use it also. Now, is there a problem? Is there any ethical problem? Is it right or wrong? Ethical problem can be reduced into a simple question: is it right or wrong? Right? So in this case also, there is not a serious problem because there might be other reasons that to make this process available and then use this process in industry, you might have to invest a lot of money, right? So if somebody doesn't use this, I take a patent, but I don't use it, nobody will say that I'm doing anything wrong. Okay, so this is another kind of patent which is useful, but it's not practiced. Unlike in the toy case, nobody would really miss it. in this case, it might be, but it's not a serious problem. Let's assume that that is the kind of invention this is. Now, you take one more. Assume that there is a patent on a life-saving drug. It's a medicine which you will save the life of a person who is sick with a particular kind of disease. Then, but I take a patent, but I don't produce it at all. Okay. So the benefit of my patent is not available to the patient in India who is suffering from this disease. But at the same time, I am not allowing anybody to make this drug in the country because I have a patent. Correct? So, is there an ethical problem here? Now we will start feeling that, yeah, there is a problem. If you have a patent for something which saves the life of a patient or a person, you should produce it and then make it available to the patient so that the patients, you are saving a human life. Now, if I take a patent and I don't allow you to make it and give it to the patient, and I also don't do it, then you can say that there is a ethical problem. That means there is what I'm doing is not right. Now, the final question would be: a patent for a life-saving drug is obtained. I make it because I have a patent. I can also make it. So I do make it, but I price it very high. For example, each tablet is 10,000 and you need to take 2 tablets every day. I have come across tablets which really cost near, at least about 10-15 years ago, it used to cost 1,200 rupees per tablet, and then a patient had to take 2 of them every day. So that is 2,500 rupees a day, and which translates into something like 75,000 rupees a month for the patient to be cured or to stay alive. Now, because I have a monopoly, I can put any price and you are likely to pay for it if you have the money, right? So that is one. No one else is allowed to make the drug in the country. And most of the patients, India being predominantly still people who cannot afford something like 1,000 rupee tablet twice a day, it is a majority of the patient might not be able to afford it. Now, is there an ethical problem? The problem will look more severe if I say that if I allowed other people also to make it and there is competition, then the price could come down to a much smaller number, right? It could be 100 rupees per tablet. Now, if I don't allow that to happen because I have a monopoly and I charge any price that I want, is there a problem? I think most of you will agree that this is not ethical, this is not moral, this is not correct, this is not right, whichever way you look at it. Right? One way of purely looking at it, like the legal part of it, is that I have made the invention, which is my invention, which is I created from my brain, and if I want to use it or not is my prerogative, my right, you can say. Now that is even though that's an argument, this is a kind of argument that India didn't believe in it when it formulated the Intellectual Property Act. The policy regarding intellectual property, when it was formulated, India didn't believe that such a thing should be allowed to happen. Now we will look at a case which is very similar to the question number 5 and the discussion on question number 5. Some 20 years ago or so, the German company Bayer, which is one of the giants in chemistry and pharmaceutical, took a patent on a cancer drug. The name of the drug, which is chemical name, is sorafenib tosylate. And it was marketed under the name of Nexavar. Nexavar is the name of the tablet that was being marketed. The symbol R in a circle next to it says that it is a registered trademark of the Bayer company. Now, even though buyer took a patent in India, it did not manufacture it in India. Strictly speaking, it is not necessary for it to manufacture in India, but it is preferred to manufacture in India. We will come to that a little later. Okay. The buyer did not manufacture that in India. It started importing and selling it in India. Okay. Now, is there an ethical problem? Strictly speaking, there is no serious problem in this. But we will come to the next step, next question within this problem, within this question. Now, at that time, what happened was Natco Pharma, which is a Hyderabad-based pharmaceutical company, approached the controller of patents for a license. This is allowed. So we will come to the compulsory license law through this case study. The Natco Pharma approached the controller of patents and said, see, these are the facts that I would like to present to you. And these are the facts. It is estimated there are 1 lakh patients suffering from liver cancer, a particular type of cancer of the liver, of the human liver. There are 1 lakh such patients in India. Now, the cost of this drug, if you want to cure it, is 2 lakhs rupees per patient per month. Now, you can ask how many patients can afford this kind of a price, even if it is a question of life and death. If you don't have this kind of money, then you can spend it. What will you do? So, and at the same time, Natco, which is a company which is applying for a compulsory license, approached buyer and said, give me a license, I will manufacture it in India, and then I will make it available to Indian patients at a reasonable price, at a low price that most people can afford. Or even the government can buy that and then give it to some people, at least, those who cannot afford it. So the buyer company did not respond because they said that we have a patent, we are importing it and selling it. So what's your problem? We don't want to talk to you at all. So they did not respond to the requests by Natco for a license. Now, what happened was the controller, I'll make this story very short, and this is the story. The controller granted a license to Natco. They said that whether, even though there is a patent held by buyer, it really doesn't matter. I, as a controller, or holding the position of the controller of patents, will grant on behalf of buyer, I will give you a license. You can go and manufacture this drug, and buyer cannot do anything about this. And the controller decided on the maximum price of the drug in India. How much can you charge? Okay, you make it, but we earlier said that buyer is charging a price in which it is 2 lakhs per month. You can't go now and say that I will manufacture it for 1 lakh per month. You will have to make it much smaller. And so they estimated what it was and then fixed the price on it. The actual price is immaterial here. If you want, you can go and look at it in the internet and you will find those details. But here the important point is that the controller decided on the maximum price at which Natco could sell this drug. So, but at the same time, because buyer has a patent, the controller decided this is the license fee that you have to pay paid by Natco to buyer. Okay, you manufacture. If this is the amount of drug that you manufacture, every month you give buyer this amount of money. So this was the order given by the controller. Now, can anybody say whether they have listened to this completely and they have understood this in general? Can anybody respond, please?
Participants, you can unmute your thing and answer. In case we have any trouble, please raise your hand.
Okay.
Yes,
So it is
go next.
in general, it is understood. What I've been talking about this has been understood. Okay, somebody has messaged on the chat that it is understood. Yes, okay, fine. I'll go back to my slides. So there. Next. So now let's say take a look at what are the principles behind the patent law in India as far as the compulsory license is granted. To be granted, and in general, what is the principle for the whole act of giving a patents in India? Uh, you might wonder why we are talking about this, because in countries like Soviet Union before uh, the Soviet Union broke up and became Russia and other countries, Soviet Union, there was hardly any patent regime. There is no law. They used to give patents, but it didn't mean anything to anybody, right? So we have to understand why there is a patent law and what are the purpose for which the patent law has been made and then executed or implemented in the country. All patent law assume that giving patents encourages inventions. How does it do? If you have an incentive that if I make an invention and take a patent, I can nobody else in the country would be able to manufacture this. So I will have a assured market and I will not have any competition for some limited amount of time. I'm sure you would have heard about all this in the patent regime till now, about the earlier classes in the last 5 days or so. So this is to encourage inventions. That means if you have the confirmation that if you make an invention and take a patent, others will not be able to use this patent, and hence you will have an assured market. So this is something which is supposed to encourage inventions. And then there are other reasons why patents are given. So that the inventions are worked in India, that is practiced in India on a commercial scale. That means it's not that you do it in a laboratory and leave it. You put it in a commercial scale without undue delay. What does this do? It improves the economy of the country because there is more business. The benefit of this patent will reach the people of India, which is also one of the main concerns of the government, or it should be. This doesn't mean, that means a patent is not given so that you can import and sell it in India. See, what can happen is that you take a patent in India, but you don't manufacture it in India at all, but you make somebody else make it somewhere else in the world and then supply it to you and you supply it in India. Why is this not preferred? It is mainly because we want to also improve the industries in India. So it is the patent is granted so that the Indian industry in general develops. You can say just because of one patent and one company will the economy of the country improve. Many times what happens is if you want to implement the patent that you have obtained, you need ancillary industries. Somebody else will have to manufacture parts, somebody will have to paint it, somebody will have to assemble it, and you assemble it and market. Somebody will have to package it for you, etc. So a lot of other industries will also improve. It will provide employment to people and so on. So this is the main reason why the government of India, when it grants you a patent, expects you to manufacture it in India, not just merely import it. That means you don't have a monopoly in importing it and selling it in India. That is another reason. Now, not only that, it also says that it should balance the rights and obligations. When you get a patent, so assume that I get a patent, I have a right to see that nobody else manufactures the patented item that I have patented. But at the same time, I have an obligation that I should make it available to the people of India. That's what the government of India tells me. Okay, you have a right, but you also have an obligation. This is a very important principle in patent law, especially in India, because it was formulated in the times when in general, even though we didn't call ourselves a socialistic country, the health of the country, the good of the people, their life was important to the nation, and hence the government decided that there should be a balance of rights and obligations. Uh, but it does at the same time, it also said that a patent in any way should not impede or harm the public health and nutrition, because the government's concern is that people should be healthy and they should be well nourished, uh, and so that we are a strong nation. So the patent law doesn't allow you to use the patent to harm the public health and then also reduce public nutrition. So that is one of the other principles behind Indian patent law. So all this put together, you could say that it should act as an instrument to promote public interest. That means it should benefit the people of India. So that's what the third line in that slide means. But at the same time, it does not prohibit the central government in protecting public health. If your patent in some way affects the health of the public, then the uh, government of India can ask you not to use it. For example, if there is a very poisonous uh, insecticide which you use to kill pests in farms, you might get a patent for that. But if the government of India realizes that it is going to harm the health of the people, it can ask you to stop manufacturing it or stop using that patent. So that is what the last line here means. So these are the things. We'll quickly go through these three, four, 5 or 6 points. One is it is to encourage inventions, that the inventions are practiced in India. It is put to commercial use in India. It is not to enjoy monopoly only for importation. There is a question of balance of rights and obligations, and this is not to impede the protection of public health and nutrition. It should act as an instrument to promote public health, and then it cannot be contrary to the protection of public health in India. So these are the principles behind the patent. So patent law concerning compulsory licenses. Now we can go back and see, so what is possible? What are the conditions under which, okay, we now have seen why compulsory licenses are necessary, and then what was the case in the case study of Bayer and Natco, what were the conditions? Now we will look at the law. This compulsory license law is mainly in chapter 16 of the Indian Patents Act, and the one which is listing this is called section 84 of the Indian Patent Law. Here you can take a look at what are the conditions. When can the government or the controller of patents grant a compulsory license to somebody? First and foremost, it should be 3 years after the grant of the patent. That means if I apply for a patent today, it will be published 18 months later, and after that it will be examined, and then there is what is called prosecution of the patent, in which the patent office might say that they are not ready to give me a patent because of prior art, which you probably would have heard by now. Prior art, and there is no novelty, there is no inventive step. Now, all that will take 1 more year. So after that, the patent is granted. So the compulsory license can be granted only 3 years after the grant of the license. So that is one condition. Now, the person who is applying for a compulsory license must show that the patent is not being worked in India. That means it's not being manufactured. In the case of Bayer and Natco, Bayer had the patent in India for the Nexavar drug, but it was not making it in India, only importing it from Germany. Now, that is not being worked in India. That is the second condition. Now, the reasonable requirements of the public are not being met. This is another clause the patent law imposes. The public, that means people like you and I, should be, we might have an expectation, a reasonable requirements. That means I need 100 tablets of this per month, or my patient needs 60 tablets of this per month. Now, because if it is being imported, and there might be delays in the import reaching India and all that, and also that the price is very high, you can say that the reasonable requirements of the public are not being met. That is what the patent controller found in the Bayer and Natco case and granted the patent. So this is the third condition. Now, the fourth one is not available at a reasonable price. I already said that approximately each patient had to spend 2 lakhs per month for the treatment, and that we can say was not reasonable because it is possible to supply it at 1/10 or even lower price, is what NATCO told the patent office, patent controller. It also says that the person applying for the patent, that is in this case NATCO, should have first tried to get a reasonable license, made some efforts to get reasonable license from the company, which we already said that earlier. We'll go back to that and see. The last line of this says that Bayer did not respond to the request of NATCO for a compulsory license. So that condition has also been met. So this is the last line here also. Then what happens? The person or the company interested in manufacturing it in India will make an application to the controller and say that I want, please grant me a compulsory license for this manufacturing this drug in India. Then there is a surprising line which comes here. The applicant can be anybody, including a licensee who is already have a license. See, in this has to be looked at in a little bit of detail. What does it say? Assume that I have a patent, or in this case, Bayer has a patent, and I have already taken a license from Bayer, and then I'm manufacturing this in India. Now, I am expected to give 1 lakh rupees per dose, that is monthly requirement of this drug to Bayer. Now, what happens? I cannot sell it at less than 1 lakh because I'm paying already this, and I have to manufacturing cost. I have cost of the raw material, packaging, selling, and then my profits and all that. So probably I will have to be selling it at 1.5 lakh rupees per month, mainly because I'm paying 1 lakh rupees to Bayer, which is what Bayer demanded as a license fee. Now, if that is the case, I can go back, even though Bayer has given me this license, I can ask Bayer, see, I'm unable to sell this at a lower price and people are still dying because they can't afford this drug. So reduce your royalty fee, your license fee. I will be able to manufacturing it at a lesser cost so that people can take it. But Bayer might refuse. That's probably that in such a case, even though there is a licensee who has a license from the company, the licensee can also ask the controller to grant a compulsory license. Now, with all these conditions being met, that is, it must be 3 years after the grant of the patent, and the condition that it is not being manufactured in India, being worked in India to the fullest extent. Reasonable requirements of the public are not being met. It is not available at a reasonable price to the people of India. And the licensee or anybody who wants the compulsory license has made an effort to get a license from the original patentee, but he has refused or he has not responded. Then I have also made an application to the patent controller, and and such condition, the patent controller will look at all these things. What does he look at? What is the nature of the invention? That is why I said earlier that it is for a toy, the controller will say, no, I will not grant you compulsory license, because the life of the people of India is not being unnecessarily or unduly badly affected. It is not a life critical kind of thing. It doesn't endanger the life of the people of India. Okay, so even though there is a patent and you want to manufacture it, I will not grant you a patent, because the nature of the invention is such that it doesn't call for a grant of a compulsory license. Now, we might also consider how long has it been since the patent was granted. If the patent was granted only 2 years ago, he will say, no, you come back after 1 year and tell me again. Till then, I will not look at your application. But also at the same time, he might say that assume that after the grant or the life of the patent is 20 years and already 18 years are over. Then he might say, okay, you wait for 2 more years, and then this become will automatically become open to everybody. Then you use it. Then also he might not grant the compulsory license. The controller might not grant the compulsory license. So, uh, has the patentee made any efforts to make full use of this invention? Now, this has two parts. One is that I have a patent. I have been trying to put this into market, but there are other obstructions, because there might be that I don't have money, that there is the technology that is required to develop or manufacture this might not be completely available, or the skill of the people that is necessary to do this is not available. I have to develop it. And then the material is not available in India for some reason or the other. These are, of course, imaginary conditions, but we must consider all this kind of thing. And then I have been trying to put this invention into market, but I'm not been able to yet. So in that case, also the controller can say that I will not give you a license, because the patent is still trying to make this happen. It's not been successful. Let's give him more time. So I will not grant you a compulsory license. Now, the another thing which is very important is that, okay, assume that the buyer has the patent, and NATCO goes and says, I want a compulsory license. Okay. Now, by granting the patent compulsory license, the controller should make sure that the applicant, in this case NATCO, is actually capable of manufacturing it. He will have to consider, or the controller will have to consider, is NATCO in the same business? Has it made other drugs before? Does it have a marketing capability? Right? Does it have the uh, technical capability of manufacturing this into according to strict standards? All this kind of things he will have to look at. If that means the ability of the applicant to work the invention in India. So assume that the patentee himself has been trying, himself or herself has been trying to work this in India, and has not been successful. What guarantee is there that the applicant for a compulsory license, that is in this case NATCO, how can they do it if that is the kind of situation it is? So the controller has to look at all this kind of thing. Now, invariably, when you want to start manufacturing something, there is a financial risk, right? You might put up a plant and then start manufacturing, and there might not be a big market for it for some reason or the other. Now, does the applicant for the compulsory license, does he have the capacity to take this risk? The controller has to take care of this also, because if he grants a patent, he will have to enforce that the licensee, compulsory licensee, has to manufacture it, and that might ruin him economically. So he has to make sure that the controller is not putting anybody's financial status at risk. uh, and the third condition is that the last condition is that assume that somebody is already infringing my patent. The buyer's patent is already being infringed by somebody in India, and then the patentee, that means buyer, has not said don't manufacture this. They have not taken any action on the infringer according to the right that they have. So in that case, in the buyer NATCO case, actually this is what happened. As a part of the defense, the buyer lawyers argued that it is not true that it is not being imported in India. There is some other company which is actually manufacturing it in India. They are infringing my patents, but we have not done anything. So that was actually looked like a very surprising argument, because the law already states that if there is already somebody who is infringing on your patent and you have not taken action, then you cannot come and say that you can't take do not grant a compulsory license. Now, not only can the controller give a compulsory license, he can also impose conditions on the person or the company to whom he grants this license. What are the conditions that he can put? Uh, if buyer has a since buyer had a patent and NATCO was asking for the compulsory license, the controller can say that you should pay a certain amount of license fee, that means royalty, to buyer, and that should be a reasonable amount of money. So how do you calculate this reasonable? Reasonable is a very difficult term to define, because what appears reasonable to you might not be appear reasonable to me, or it might not appear reasonable to somebody else. So how is this decided? So let's take a simple, straightforward kind of example. In the buyer case, what is the market that is available worldwide? What is it likely that the buyer is, what is the amount of money that buyer has already spent in developing this drug? Because drug development takes a lot of money. What is the effort that has been put? And then will they get a return if I grant a compulsory license? So you must make sure that buyer is not cheated of any money, that they would naturally or rightfully they deserve to make that amount of money. So he has to, the patent controller has to take that into consideration. Uh, and then you should also make sure that the patented the invention is worked with reasonable profit to the licensee, to who gets the license. And he can also say that the maximum price at which this would be sold in India would be this. That means in the case of buyer and NATCO, if I remember correctly, the controller said that the monthly dose should not cost more than 10,000 or 12,000 rupees in the Indian market. That was the condition imposed by the controller on NATCO. And also that the license is granted as a non-exclusive license. I don't know whether you already know about exclusive or non-exclusive license. Assume that buyer has a patent, and I can go and ask buyer for a license to manufacture that drug in India on an exclusive basis. That means buyer cannot give the same license to anybody else. That's called the exclusive license. But the price for that the license fee for that would be very high. But I can say, okay, you give me a license, but I want a non-exclusive license. You can give it to 10 other people. I don't mind. I will do practice your patent, and I will give you this amount of money. That will be far less. So the controller must make sure that the license is granted on a non-exclusive basis. If somebody else comes and says, I also want to manufacture the same drug, give me the license, the controller will give the license to that applicant also at the same conditions as in the previous case. And also, this is very important, if I take a license from buyer, from compulsory license from buyer, okay, which is given by the controller, I can't give it to somebody else. I can't ask somebody else to use it and manufacture and supply it to me. I should manufacture it. That is another important thing that the controller has to impose. Uh, the controller can also say that assume that the patent term is going to expire in 2050 to 25. He can say, the controller can say that, okay, the compulsory license is up to year 2025. But he can also say, no, I will grant you this only for 3 years. Because after that, there might be many other considerations why this is so. Because it might also say that it will give some time to buyer and the original licensee to start manufacturing it. At that time, he should be able to enjoy the monopoly that he was originally granted. So he can, the controller can say that I will grant you the compulsory license, but it will be only up to a part of the term of the patent. And the patent is granted mainly for the supply of this in the Indian market. It is there are other clauses for compulsory licensing for manufacturing for other countries, but we'll come to that later. But in this case, it is only for manufacturing and supply it in the Indian market. Because, as you know, the patent regime is jurisdictional. That means a patent held in India is useful, it gives you protection only in India, not in other countries. So the Indian government can grant you a compulsory license only for manufacture and supply in India, not for other countries. That is another thing that the controller can impose on the compulsory license that is being granted. So this is up to a normal case. That means somebody has a grant of a patent, and then there is somebody else comes and asks for a compulsory license, and that is a kind of condition. Assume that there is a national emergency, or in cases of extreme emergency. For example, there is a war that is coming on, or there is as in the present case, there's a pandemic going on, right? So, in such kind of cases, which has been declared by the government of India as that there is a national emergency or an extreme emergency, then the and then the government of India declares such a thing in the official gazette. Then an application made under this notification. That means I can say that the government of India has declared that this is a national emergency. So I'm a person interested in manufacturing this. So please give me a grant. Then the controller can grant me a compulsory license at conditions that he thinks fit. He doesn't have to go back to the original licensee and ask. He need not find out whether 3 years has been passed and all that kind of thing. So the patent law gives the controller a lot more power in the case of natural emergencies, national emergencies, and extreme urgency cases as declared by the government of India. Yeah, then it also says that the articles must be manufactured, that is, the patented item must be manufactured, and it should be the product should be available to the public at the lowest price that is possible, over and above the profit that a patentee can have reasonably. So these are special provisions, and these are applicable only in conditions of cases of extreme emergency, or in cases of national emergencies. So what it also means is that under norm, assume that in the NATCO buyer case, when NATCO approached the controller and said that it wants a license, the controller has to call buyer and say, why are you not doing this? Should I grant a compulsory license? He should talk to the patentee, also hear from the patentee, and then if the patentee gives reasons why the controller should not grant a compulsory license, he should convey that to the licensee, that is NATCO, and then ask their opinion, then finally take a decision. In the case of national emergencies or urgent cases, the controller need not do any of this kind of dialogue with the patentee and the compulsory license applicant. He can take care of, he can weigh the pros and cons, look at the case dispassionately, and if he thinks fit, he can give the compulsory license to uh, the applicant who is asking for a compulsory license. But also under the cases, something like the government has already declared that these kind of cases, uh, all this kind of procedure need not be done, and the controller can take a decision on his own or her own, and grant compulsory license. What are the kind of conditions that we are talking about? In the case of HIV, human immunodeficiency virus, or immunodeficiency syndrome, in malaria, tuberculosis, and so on. And it is, as it can be seen, probably in the case of COVID-19 also, if there is somebody makes an application for making the manufacturing the vaccine, or if there is a new drug invented for curing COVID-19, and then uh, the, the government has declared that this is a national emergency, anybody can approach the controller and ask for a license. So that's what this says. There are other cases. For example, there is a small country which doesn't have uh, production capability at all. For example, it might be a country like the West Indies, where the industry might not be uh, very capable, or there is a country like Haiti in South America, where the industries have not grown because it depends purely on, let us say, tourism for its economy. In that kind of a country, and there is a disease that is coming, and the assume that, as in this case, the buyer doesn't have a patent taken out in the country of Haiti or West Indies. Then, if the West Indies government and the Haitian government asks India, you are capable of manufacturing this, will you please manufacture this and supply to us? Buyer doesn't have a patent in our country, so you are free. In that case also, for the sake of helping neighbors or the other countries, India can grant a compulsory license to somebody in India to manufacture this and supply only to those countries, but not supply it in India. So this is a special case where, to help countries which do not have manufacturing capability for drugs only, this is not for any other patent, this compulsory license can be granted in India purely for supply outside. And any patent law, or any law for that matter, if there is an instrument like a compulsory license, there should also be a law which states when does it stop, when does it exit. That means an exit clause. Even for something like an agreement between a landlord and a tenant, when they have a rental agreement, there is not only an agreement as to how you enter into that agreement, you should also have a means of exiting the agreement. So the compulsory license might also should also have a law like that. So what the law there states that the compulsory license may be terminated on application by the patentee. That means, after, let's say, the compulsory license has been granted by the controller to NATCO, after 5 years or 6 years, buyer can go and say that we are now manufacturing it in India because we had the original patent. Can you cancel the compulsory license to NATCO? And then the controller can take into consideration all facts and say that the compulsory license granted to NATCO has now stopped. That means the NATCO will have to stop manufacturing this, and only buyer can start manufacturing this in India. So these are the special provisions that are available. Now, a compulsory license is granted when somebody comes and says that, uh, for example, in this case, buyer has a patent in India, it is not manufacturing it in India. I would like to manufacture it in India, so please give me a compulsory license. But even without that, if the controller is convinced that the patent has been granted, some amount of time, for example, 5 years or 3 years has passed, and then even then the patent is not manufacturing in India, the controller can revoke the patent completely. He says that I'm taking back the patent right that we had granted to you earlier. So how does this happen? The grounds on which this can be done is again, as in the previous case, the patented invention has not been worked in the territory of India. How does the uh, controller know that this is happening? That means the patent is not using this in India. We will come to that immediately after this. But he can also ask for a survey and then say that the reasonable requirements of the people of India are not being met with regard to the patented invention. Uh, and even though it is being manufactured and then sold in India, it is not at a price which the Indian people can reasonably afford. So then also he can decide that this he can revoke the patent. So uh, how does the controller know that the patent has not been worked in India? There is a clause in Indian patent law which says that every year, every patentee, after the grant of the patent, should inform the patent controller what efforts are being made by the patentee to manufacture the patented article in India, or what efforts are being made, or how much am I producing, what is the volume of business I am doing with the patented article. So this is generally referred to in this field as Form 27, because that is a form that is used by every patentee every year to inform the patent office what they are doing about uh, working the patent in India, or how much have they already started working the patent in India, right? So for every year it has to be the patent office has to be informed. But also at any time, the controller has the power. The patent law very specifically states that the controller has every right to ask any patentee about the manufacture or the working of that patent in Indian territory. So the patent controller can write a mail to, for example, in this case, buyer, and say, what have you have a patent for this drug in Nexavar in India. I would like to know how much you are manufacturing in India, how are you supplying it in India. He has a right, and the patentee has to supply this information. So based on this information, if the government, if the controller comes to realize that these three things, that means it is not being worked in India, the reasonable requirements of the public in India are not being met, and then it is not available at a reasonable, affordable price in India, he can revoke the patent, and the patent will become defunct. Okay, so this is the overall look at the uh, patent law in India as concerning compulsory licensing. There are a lot more details. That there are something like 7 or 8 clauses in the chapter 16 related to this, but I have given you an overall picture because the uh, any section of the law for any chapter in the patent law, if we want to go about it in complete detail, it will take at least 2 days. So in the available time, I have tried to give you a overall and most important, so let's say the salient features of this patent law in India, I have tried to give you. And then if there are any questions, we can look at it after this. But before I conclude, I would like to tell you that in the when the uh, compulsory license was granted to NATCO on the Bayer patent, there was a lot of commotion in the patent world, all over the world. People said that this is not correct. This such a law should not exist at all, and all that kind of thing. So people even went to the extent of saying that India is a backward country. This is not helpful to patents. So taking a patent in India is useless, and all that kind of thing. But at the same time, there are countries. One of the examples that I remember very clearly is that people, the countries like New Zealand, took note of this and started wondering: is it a part of the law that we should also have in our country? That means they found that compulsory licensing law, which is in India, is good. Should we start adopting that law in New Zealand also? Whereas some other countries said that India is a backward country and all that, this is not correct. And there is a lot of noise about this. So I would like to give you some information about this also. Are there compulsory licensing law in other countries? Let's take a quick look at this. The United States law, statute number 28 under US law 1498 says, this is the actual quote: under patent law, compulsory license is a statutorily created license. No, this is what somebody has written about this statute, and has said that uh, some countries allow certain people to pay a royalty and then use an invention without getting the consent of the patentee. US does not recognize compulsory licenses. This is the statement made in a website that you can look at. But there are other nations which have compulsory licenses. That means what these people are saying, that this United States law is superior as far as patent law is concerned. United States law is superior to law in other countries. But this is strictly not true, because there is that is the statute 28 USC 1498 says, for the purposes of this section, that is the use of manufacture of an invention described in and covered by a patent of the United States by a contractor, a subcontractor, or any person, firm, or corporation for the purpose of the government of United States of America, and with the authorization for the or consent of the government, shall be considered as use or manufacture for the United States. That means what it is trying to say is that assume that the federal government, an authority of the federal government, allows a person manufacturing to manufacture a patented item without taking any license from the patentee. It is allowed. See, this is actually called compulsory. It is not called compulsory license, but it is compulsory license in a different terminology. In India, it is said that the public health considerations or the use of the public is very important. In America, they say that it is the defense of the nation is very important, and hence the government can grant a compulsory license. In this case, it might not even the manufacturer, like a company like NATCO, need not even apply. The American government itself can declare, can call a company and say, you manufacture this, there is a patent, but you don't worry about it. If the patentee comes after you, I will handle the case. So compulsory license exists in other countries, especially in the US, which made the largest amount of noise. there also it exists. So Section 48 of the British law, that means United Kingdom law, also allows, says that applications can be made to the controller for him to order a grant of license under patent to make an entry in the or make an entry in the register, and a applicant can have this patent as a right? Even though, for example, taking the same name, even though buyer has a patent in England, if the government declares that it is no longer necessary, buyer can any longer go after somebody and say that you shouldn't manufacture. The government has the power to declare that this is something that means it is actually granting compulsory licenses in UK also. The next part, that is those grounds are basically concerned with the monopoly conferred by the patent in question is operating against public interest. That's what the case in the uh, 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 Bayer and Natco case was also the same kind of thing. In Europe also, there is, the law says in some cases national authorities may license companies or individuals other than the patent owner to use the rights of the patent without the consent of the patent owner. This is also compulsory license without calling it compulsory license. So, in conclusion, what I would like to tell you is that if someone tells you anything to the contrary, that means Indian patent law is backward, that it has compulsory license. Please don't believe this. In India, actually, there is compulsory license has been granted only once. But if you look at the kind of cases that I was talking about in the US, there are even in a very brief search on the net, I can find 6 cases where the compulsory license has been granted in the US. One of the cases that I can tell you is that there's a kind of goggles that you need to protect your eyes from lasers in a particular kind of weaponry has been uh, thousands of those units have been manufactured by a company which manufactures eyewear, and the compulsory license has been granted by the American government to that particular company. If you look on the net, you will find umpteen number of other cases also. So with this, I will conclude, and then anybody has any questions, you could ask me. Thank you very much.
Thank you, sir. Thank you, sir. Thank you very much. So anyone having questions can put forth the questions.
Can you give me just 2 minutes? I'll go get myself a glass of water and come.
Yes, ma'am. Yes, sir. Yes, sir. If you have any questions, participants, you can unmute your mic and go with the question. Yeah, wait, sir. I'll Ravi Prasad, sir. Wait, sir. I'll do it. Ravi Prasad, sir, I have unmuted it. Kindly check it out. Hello. Ravi Prasad, sir. Ravi Prasad, sir. Then Gupta, sir. Wait. Gupta, sir, now you can do it also. Yes.
Thank you. Just I'm waiting for him.
Yeah, yes. Anuradha, ma'am, I am also unmuting your mic. Anuradha, ma'am, I have also unmuted your mic, so you can go with the questions.
Hello, I'm back.
Yes, sir. Yes, sir.
Yeah.
Good morning,
Are
sir.
there any
I
questions?
have one query.
Yeah.
Suppose I have invented something and also want to keep it as a trade secret. Okay, then it's obvious that I should not go for the patent. Okay, then what the other way I should follow?
No, your question
Because
is not very.
no, whatever I am making it, I want to keep it under my control, under my hand. So if I will
Okay.
go for the patent, then obviously one can go for the compulsory licensing to give to other one or the third
Yeah.
person. I
Yeah.
don't want that thing. I want to keep it as a trade secret under
Yeah.
my control only. Then, then it's obvious that I should not go for the patent. Then what the other
Exactly.
way I should follow so that the thing remains under my control.
Yeah. See, first and foremost thing is that in Indian patent law, there is no law for trade secrets.
Okay.
Okay. In America, for example, there is a law for trade secrets also. How it works loosely in the US, if I can give you a very brief explanation, is that you approach the authorities and say that I have a method for doing this such and such, right? And then the formula or the way it is to be made and all that has been written down in a document. Only 3 people in my company know the complete details of this. They are the board members or whatever. So, just 1 second. Hello.
Yes, sir.
Yeah. So, I'm going to write whatever is the secret that I want to maintain in a document, or I put it in a CD or in a hard drive or anything like that, and then I will keep it. Just 1 second. There's a call. I'll take this. Hello. Hi. I'm fine. I'm in a midst of a talk. What is it? I'll call you after an hour. Okay. Okay. So, yeah. So you put that into a lock and key and then say that it is in a bank vault, and then nobody has access to this. And you should show that you are taking all efforts to show, to make sure that the secret is not known to too many people. For example, this is what has been done by the Coca-Cola company, which is one of the most famous uh, trade secret examples in the US. So they have a formula for making Coca-Cola. That formula has been written down and it is known only to 3 people in the world at any time, right? So if somebody, one of them has to go and look at the formula even in the bank, at least one more person should be present to make sure that it is not without the knowledge of the other two, somebody is looking at it again and then taking away what is to be done with it. So what Coca-Cola does is that in the secret part is manufactured as a concentrate and then supplied to everybody who does bottling, and they don't know what is inside. So they add this concentrate to water, dissolve carbon dioxide in it, carbonate it, put it into bottles and cans and sell it. So this is the kind of thing that America has. India has no such law. So what you need to do is you should take all efforts to make sure that it is kept a secret. Then bind your employees who are is likely to know at least a part of what the secret is into a contract saying that this if there's a breach of contract they will go to jail, right? So you should take only that kind of an effort and keep it under you. Make sure that it is not available to anybody else. This is all you can do. So in India, the protection is provided only by the contracts law or an agreement law. That's all. That's what you should do.
Okay, thank you.
Yeah.
Hello, sir.
Yeah.
Yes, I have a query. Like nowadays, whether this compulsory licensing is required for pharmaceutical industries? Like, for example, nowadays, some of the companies like Serum Institute of India, they are manufacturing the corona vaccine, which is from AstraZeneca. So, do they have this compulsory licensing?
No. Serum Institute of India, even before the vaccine was developed, came to an agreement with Oxford and AstraZeneca that when the vaccine is approved, we will manufacture it in India for you. Okay? So, there is already a license being granted to Serum Institute of India by Oxford and AstraZeneca even before the vaccine was approved. Not only that, Serum Institute did a very important thing. They started manufacturing the vaccine even before it was approved and kept stockpiling it for 1 year nearly. That is why the moment the vaccine was approved, they could start distributing it. So, but now if somebody says that in India, we also want to manufacture because the requirements of India is not being met, India can actually grant a compulsory license if there is already a patent has been granted in India for this AstraZeneca vaccine.
Okay, okay, sir. Thank you.
Yeah, yeah. Any more questions? Is there anything, any part of the thing that you did not understand or you want more details about it? You could also ask, or you can ask any other questions also.
Any more questions, participant? Hello. I think no, sir. Yeah, Gupta sir, if you have any questions, please, you can. Okay. No. Thank you, sir. I think no more questions, sir. We can have a group photo, sir. 1 minute, sir. Okay.
Okay.
Participants, kindly switch on your cameras. Switch on your cameras, please, kindly. Okay, sir. Thank you, sir. Thank you very much.
Thank you. Thank you very much. Thanks, everybody.
Thank you, sir. We'll meet by 11, like for the next session at 11:30. Okay. Participants will meet by 11:30 and we'll have the test link will be posted in a GCR as well as in a WhatsApp group and here in the chat by 1 o'clock. And you can attend the test till 5 o'clock. Okay. Thank you, sir. Thank you. Any thing you want to ask me? Any other queries if you want to ask me? Thank you, sir. Thank you very much. We'll meet in the next session.